Hello and welcome to today's episode 13 of Crystalcast. My name is Ross and I'm an immigration lawyer based here in Sydney. A very warm welcome to those of you that haven't listened to our podcast, and welcome back if you are a regular. We've got quite a bit to cover today, which is excellent. First day of summer, so really exciting. We've just got a couple of more episodes to go until the end of this season. So thank you for all of those who have supported us throughout the podcast. I hope that you find the information that we put out useful every week. We do try to keep it interesting and try to keep it as varied as possible. So if you like what you're hearing, make sure that you do subscribe to our channel so that you know when the new episode is out. We put out episodes generally every Friday at around 5 p.m. Australian Eastern Daylight Time. Now, what I wanted to discuss today are the permanent residency provisions for 482 visa holders. We have touched upon that quite a bit in this season, because when we've started this podcast, the information just sort of started to flow through, and further announcements were made throughout the weekend as well. So this is going back to 25th of November. So now that it's been confirmed, I do want to talk about how that would work in practice if you are thinking about transition towards permanent residency. And obviously, if you're a migration agent or an immigration lawyer, I'll cover how these provisions work. I also do want to talk about state migration and the updates that we had in relation to state migration. It seems to be that at the moment, states are holding what I would call a micro invitation rounds, and I can talk about sort of how that works and what occupations are being invited, and what you can do for your clients, and if you are an applicant, what you can do to potentially increase your chances, and also what not to do, I suppose. I will also touch upon visa cancellations. A very important topic. Never a nice thing to deal with a visa cancellation as a migration professional, and if you're a visa applicant, I would imagine that would be even more stressful for you. So what we'll talk about is the actual process and how to deal with it in a stress-free manner. And to finish off the podcast, I'm going to talk about something a little bit different, so I'll probably leave that as a surprise, and as the episode continues, I will finish off with our topic of the week. Sit back, relax, and enjoy this week's episode of Crystalcast. Now, on to our first segment, which is permanent residency provisions. Now, the Department of Home Affairs has released information, as I've mentioned in our previous episodes, earlier in the year, that essentially all sponsored employees are going to be eligible for permanent residency at some stage. In terms of what that was going to look like was a little bit ambiguous, and whether or not the changes were going to be retrospective, whether there's going to be any caveats attached to it, was very unclear at that stage. However, the Department of Home Affairs has now released the regulations around permanent residency. So what we're discussing today is having someone who's currently working on a 482 visa or a 457 visa and is transitioning to permanent residency via the 186 temporary residence transition stream. Now, under the previous transitional arrangements, the way that it would work is the applicant would essentially need to meet two requirements. So the first requirement was what was called an individual who would fall within the concession period. Now, the concession period referred to someone who was in Australia between 1st of February 2020 until 14th of December 2021 for at least 12 months. And this covered sort of the height of the pandemic. So the first criteria is that you were in Australia for at least 12 out of the 18 months during the concession period. And the second part, which is probably more the most important one, is having to have worked with your sponsoring employer on a 482 visa for at least 3 years. Now, the good news about those provisions were that it was irrelevant whether the occupation was on the short-term list, whether the occupation was on the medium-term list or the regional list. So it did create a bit of versatility in terms of being able to, as a business, nominate employees for permanent residency. There was, however, a catch, and actually two catches. The first one is that the individual must have been in Australia during the concession period. So essentially, if someone arrived to Australia after 14th of December 2021, or if as of 14th of December 2021, the individual hasn't lived in Australia for at least 12 months or resided in Australia, they would not be able to access those provisions. And as you can appreciate, that cohort is going to get smaller and smaller. Now, the second issue was that there was I suppose lack of clarity in relation to when those provisions would finish. Now, if you read the legislation that covers these provisions, the legislation states that the instrument covering the provisions ends or has a sunset clause on 1st of April 2032, which would in theory give plenty of time for a number of applicants to transition towards permanent residency. However, there's conflicting information in the policy section and also on the department's website, which states that the permanent residency provisions would end on 1 July 2024. So this means that unless you were able to reach the 3 years with your current employer on a 482 visa and you meet the concessional periods, you would not be able to transition towards PR. So that made the cohort smaller, and also it made new individuals being restricted from accessing those particular provisions. Now, as of 25th of November, being last Saturday, the cohort has widened, and what we've got now is there's two things. So the concession period, or the requirement to have been physically in Australia between 1st of February 2020 until 14th of December 2021, that has now been removed. So it's largely irrelevant when you've arrived to Australia and on what visa. So that's part one. The second part, which is a bit more lucrative, is the period that you have to work for your sponsor has now been reduced to 2 years instead of 3. But it is still important to remember that the qualifying visa continues to remain to be either a 457 visa, which would be quite rare given that it's now obsolete, or the 482 visa. So essentially, if you are an individual on a 482 visa, you will be eligible subject to all eligibility criteria after working with your current employer in the same or similar occupation holding a 482 visa. There's been a couple of other amendments as well in that particular instrument. One of those amendments includes the widening of the age exemption based on high income threshold. Now, the previous provisions required the applicant to earn high income for at least 3 years whilst working with their employer. This has now been reduced to 2 years. So if you earn above the Fair Work High Income threshold, which currently sits at around 167,000, irrespective of your age, as long as you worked for the employer on a 482 visa for 2 years, you would qualify. There are also some arrangements for health professionals as well that may qualify for an age exemption. So that's definitely been some good news. And what's really good is that there's now a streamlined provisions. Now, even though the instrument specifies that there is no occupation list which is applicable to the 186 program, it's still important to remember that all temporary residence transition provisions still apply. Now, in order to apply for a temporary residence transition stream, the client must either hold a 482 or a 457 visa. And if you were to apply for a 482 or a 457 visa, then your occupation must have been on the list. So in a way, occupation lists do matter. But the good news is it's largely irrelevant whether you're on a short-term list, medium-term list, or regional list. So that's definitely been a welcome change. I think it's really important, though, to ensure that if you do hold a short-term visa, for example, and that's only valid for 2 years, if you have taken any unpaid leave, just remember it doesn't count towards your eligibility, and it is important to do a full eligibility assessment. So it's important not just to rely on the fact that, just because you've been in an occupation for 2 years with your employer on the 482 visa, it gives you access to those provisions, but in no way does it make you 100% eligible for those for that particular stream. So therefore, it is important to seek professional assistance to ensure that, you qualify and also that the employer qualifies as well. There's a number of different criteria that needs to be met. So therefore, every application does need to be assessed on its own merits. So definitely some really, really good news, to start the week and I suppose to finish the week with this podcast. And there will probably be further announcements made, hopefully before the end of the year, in relation to the migration strategy, which has been in the works. And as soon as that information becomes available, you can be assured that Crystalcast will be the first to put it out for you. Now, in other news in relation to state migration, we've received a number of emails in regards to the current invitation rounds and what's happening with those, and whether there's going to be an increase in the allocations for the current financial year. So what I might do is I'll address the latter question first in regards to increase of state allocations. Now, state allocations are based on the number of places that are currently available to fill in the planning levels. Now, one of the major issues that we've had this year is the fact that you've got a number of applications, both in the 190 and the 491 state-sponsored stream, being lodged with the Department of Home Affairs, which take into account the overall planning levels. So when you've got a lot of applications lodged in the system, it's not possible for states to issue more allocations than required. So when it comes to answering the question, are we going to get more allocations for the states? It's a little bit difficult to judge at this point in time. I suppose what we can do is look at some of the historical data that we have available, and what we can look at is what happened last year. So, for example, last year in December, a number of states have received an increase in allocations. Specifically, I'm referring to New South Wales, and I'm also referring to Victoria. Their allocations were almost doubled, and that was quite a pleasing result. So it is possible that at some stage the allocations may increase, but it's just difficult to say whether or not that's going to happen. Now, what we have noticed this year, which is quite different to previous years in state migration, is that states are holding what I would call micro invitation rounds. So they tend to be a little bit more frequent, but just a smaller number of invitations are being issued. So, for example, we've published a number of articles or blog articles on Crystal Press. The ACT tends to hold invitation rounds on a regular basis, every fortnight or so. I'm aware that Queensland has issued a small number of invitations earlier in the week. Victoria held an invitation round on Wednesday, and it's also anticipated that other states would most likely follow the same sort of process as well. Now, if you are a visa applicant, what can you do in terms of increasing the chances of receiving the invitation? One of the things that I would say is what not to do, and that is just to go around state hopping. So what I mean by that is that if you've been waiting for a couple of months or maybe a little bit longer to receive the invitation, I think the worst thing that you can do is to move to a different state and hope that you'll receive the invitation sooner. The reality is that all states have requirement whereby you either need to live and work, or potentially both, in that particular state for a certain number of months. So therefore, even if you were to move to a different state today, most likely you will not be able to just go ahead and become eligible for a particular state nomination program. Now, I'm aware that there are different state nomination streams, so potentially you may be eligible under a particular stream, but in having said that, moving to a different state just because it's perceived to be easier doesn't necessarily result in receiving the invitation. So the best that you can do in terms of ensuring that you're invitation ready, make sure that you haven't overclaimed your points. So when you talk about employment experience, for example, ensure that you have reference letters to back it up with. Ensure that all of your documents remain valid, so skills assessment, English language test, and just have a think about areas where you can improve. So the most obvious one being English language, potentially going from competent to superior. I'm not saying it's an easy task in any way, shape or form, but it is something that can potentially be done to improve your chances. At the end of the day, I don't think it's possible for someone to predict when someone will receive the invitation. The reality is, our firm, for example, had chefs who've been invited on 75 points, but we also have engineers who are sitting on higher points and they have not received invitations. So it's a little bit difficult to predict when someone's going to get the invitation, just because that particular information is not being made publicly available. And that is just to ensure that states are able to adjust their program according to their economic needs. So the best that we can all do is to ensure that we don't overclaim points, that we remain eligible, and whenever in doubt, ensure that you do reach out to a migration professional. A lot of states do have quite strict requirements this year in relation to the number of nominations that can be issued. So if you do receive a nomination and you can't accept it because you don't meet the requirements or you are no longer eligible, you are putting yourself at risk of potentially not receiving another invitation this financial year. Now, moving on to our next topic, and that is receiving a notice of intention to cancel or having a visa cancelled. What we generally talk about in this podcast, well, we talk about a number of different topics. We talk about getting a visa. We talk about things that involve getting a visa. But what I want to talk about today is what happens when you have a visa and your visa becomes subject to cancellation. Unfortunately, it's something that is becoming a lot more prominent, and that is because immigration is becoming more complex. The visa conditions are becoming more strict, and the data matching system that you've got between the Department of Home Affairs, the Australian Taxation Office, is becoming more efficient. So it's quite easy these days to track when, say, for example, a student is working more than 48 hours per fortnight, or if someone who is on a sponsored visa no longer works for their employer because of the data matching system. So what happens when you no longer meet the conditions of your visa? Your visa could become subject to cancellation on the basis that the visa or the purpose for which the visa was granted is no longer there. Now, that cancellation would be issued under Section 116 of the Migration Act, and the issue with cancellations, and one of the main challenges with cancellations, is that it's generally a fairly quick process. So when you do receive a notice of intention to cancel, it's important that you contact a migration professional that specializes in cancellations, because there's different types of cancellations. So the one that I've mentioned, Section 116, talks about general cancellation. So when someone doesn't comply with the visa conditions, someone's visa no longer serves a purpose, or maybe they were never entitled to a particular visa. So it's a fairly broad cancellation. But then you've got your specific cancellations. So say, for example, someone has provided false or misleading information as part of their application and received the visa based on that particular situation. Now, the visa could be cancelled under Section 109 of the Migration Act. And then you've got something that's a bit more serious, and that's called Section 501. And this is where if an individual serves or receives a prison sentence of 12 months or more, or has multiple prison sentences, or has what's called a substantial criminal record, their visa could be subject to cancellation under Section 501. Now, all of these cancellation provisions have different ways of dealing with them. The most serious one being Section 501, just because there are very strict timelines in terms of when you need to respond. If the visa has already been cancelled, when you can lodge an appeal or a review of the cancellation, and during which time or the time frame you have to provide the documents. It's also important to remember that your general cancellation cases and also cancellations based on false or misleading information are heard at the Migration and Refugee Division of the Administrative Appeals Tribunal, whereas if it's a Section 501 cancellation based on character, that case would be heard at the General Division. And in the General Division, rules of evidence apply, so therefore it becomes more of a court-like situation. So it's important to understand what section applies to your particular circumstances when it comes to the visa being cancelled, and seek advice. You may need to provide further information. You may receive a potential bar. So, for example, if the visa is cancelled, you may be barred from applying for further visas, such as a bridging visa, and you may be put in detention as well, once again, depending on the circumstances. Now, it becomes a little bit stressful, and more so for the applicant if, let's say, they do receive a notice of intention to cancel, or potentially the visa has been cancelled, and the practitioner is engaged at the last minute, because it becomes difficult to formulate a strategy and to be able to lodge everything in a succinct manner. Whenever someone's rushing to do something, it's easy to make mistakes, it's easy to overlook something, and you are relying on things like the AET's portal, which could potentially go down and you can't lodge the application, and so forth. So my tips for when it comes to dealing with cancellations: understand why your visa has been cancelled, or why your visa is being considered for cancellation. Understand the difference between various sections of the Migration Act. So having your visa cancelled on character grounds is very different to having your visa cancelled because there's no longer a purpose for that visa to exist. So it's important to understand the reasons, and also it's important to understand whether there's any prospects of success for your case. So some of the cases that we've dealt with, the cancellation might have been warranted. So, for example, someone might have provided false or misleading information and their visa should be cancelled, but because there are what's called compelling compassionate circumstances, the case officer or the Administrative Appeals Tribunal may consider revoking the cancellation. So there may be a way out, but each case is different. So it's important not to compare your situation to a friend or a colleague, and review the case on its own merits. There's quite a bit of case law also available on the AET's website if you wanted to do your research. So if you are a migration practitioner, it will benefit you a lot to have a look at some of the cases that go before the AET, so that you can sort of understand the types of cases that are heard both at the General and at the Migration Division, and also what sort of grounds are being put forward to avoid the cancellation. Alternatively, if you don't specialize in a particular cancellation provision, seek advice from someone who has had experience in that particular section, and also someone who was able to have the cancellation revoked. And now on to our final topic of the podcast, and that is working a 4-day week. Now, before I get into that, let me just explain background as to why I've decided to cover that in the podcast, and I'll be covering this topic quite a bit. Now, there's been quite a lot of research done in relation to just how productive we are at work. Some of you may work part-time, some of you may work full-time. But what I'm talking about here specifically, and that's just because that's something that I can relate to, would be an office job where you work 9 to 5, or maybe you work longer. You could be a business owner, running your own business, and you're doing those standard sort of, Monday to Friday. When it was first suggested to me to look into a 4-day week, I thought that being in migration, it would be next to impossible to do that because, demands always arise. Things happen at the last minute. It would just be very, very difficult to manage a 4-day week and just not be available. So I was really closed off to this particular concept, and I've actually published an opinion piece on that at crystalpress.com.au, which you can read. But it got to a point of where I was doing casework. I've been teaching CPDs, recording this podcast, doing blogging. So it got to a point of where basically I was just running from one office. So we've got our recording studio on one side of the office, and we've got our office on the other side of the floor. So I'd be running up and down, and to be honest with you, it gets a little bit exhausting having to do that sort of changing back and forth. So I thought, well, what if I was to minimize the number of days I work? If I was to go and do what I do, that is teach, provide immigration advice from Monday to Thursday, and on a Friday, I'm still going to work, but I'm going to work on things that I really enjoy doing. And that includes talking to you, recording this podcast, doing my blogging, working on future projects, and just having a bit of me time, going for a run, going to the gym, catching up with friends. So doing things that you would not be ordinarily able to do during the week because you work. So this is my first week. This is the first week where I'm trialing a 4-day week, and I wanted to share my experience, and I'm sure that I'll be covering this quite a lot. What I've noticed, and as I said, I've done quite a bit of research about it, the whole idea is that you maintain the same level of productivity without working extra hours. So at first I thought, well, how am I going to do 5 days worth of work in 4 days? The reality is that most research demonstrates that on average, we're truly productive for about just under 3 hours per day. So if you're in the office for 8 hours, you're really working for about 3 hours. The rest of the time is spent having meetings that may not necessarily need to happen, going out for a coffee, liaising with colleagues. I procrastinate. That's my biggest thing. I procrastinate. Spending time on social media, I'm guilty of that as well. So when you take all of that away, really what you're left with is just about 3 hours worth of work. And, even if you spend on average 1 hour per day on social media at work, if you remove that away, that's 5 hours that you're saving. So what I've noticed by doing a 4-day week this week, I became very conscious of my time and how I spend it. I've noticed that I was logging onto social media much less. In fact, I don't think I have been checking social media whilst I was at work because I was aware that Friday is my day to do project work or just to relax and unwind and not be involved in doing immigration casework. So I became very conscious of my time. I also became very conscious about I've got 8 staff at the moment. I became very conscious about at what time I would be available and also at what time I would not be available. So the majority of my work has been spent in ensuring that if I was to organize any meetings, that they would be productive and that we wouldn't have to reschedule, because all of that takes time. If you hold a meeting, no one's prepared, you have to reorganize the meeting again. So it's been interesting because there was just that mental shift in having to ensure that every hour that I'm in the office or doing work, I'm aware of what's being done. Now, what used to happen in the previous weeks is that I would always have to sort of ensure that the blog was up to date, that the episode was recorded, that I had sufficient time to do it. And interestingly enough, today, that pressure wasn't there, because I knew that I have no client consultations. I do not have anything due today. What I need to focus on, or what I want to focus on, is what I've chosen to do. And that is, I wanted to do this podcast. I wanted to go for a run in the morning. I wanted to have a sleep in, which is a luxury. And I was able to do all of that without having to worry about any deadlines or anything else that might have been promised during the week and has not yet been done. And I do not feel more tired in any way, shape or form. I don't feel like I've done 5 days worth of work in 4 days. In fact, I think what had happened there is that my day has become more structured and more organized, and by having this extra day to be able to do things such as this, for some people it might be just taking an entire day off, and that's fantastic. Or maybe it could be a day where you want to spend time with your kids or do life admin, whatever it might be, but it's that guilt-free day where you can actually sort of sit in peace and just enjoy your time. And that's why this week I've decided to have a solo podcast, to be able to sort of share that experience with you, with the listeners. And so far it's been great. So what I'm planning to do is I do want to record this for probably the next sort of 3 months or so, just to see whether it is possible in the modern day to work a 4-day week and be able to manage the same level of productivity. I've also reached out to fellow colleagues to see how they feel about a 4-day week. So a very general question that was posted on one of the forums, one of the migration forums. How would you feel about working a 4-day week? The response was great. So if you are listening and you were one of the contributors, thank you. It has helped me quite a lot with my research, because, as I said, it will be covered at length during these episodes. But one of the things that I found, which was quite interesting, is that most people were receptive to it. But I think the main concern was that whilst most people wanted it, the concern was, how would you manage client expectations? How would you manage your workload? Let's say if you were to take Friday off, would you come back on a Friday and feel like you're a day behind? Now, it's very early days for me to say whether it's working, whether it's not working. I might be recording an episode in 3 weeks and I might say to you, well, look, I tried the 4-day week, didn't work, going back to 5 days, and that's okay. But so far, surprisingly, it's been quite good. I have to say this has probably been one of the most productive weeks I've had, and I've done a 4-day week. So today there has been no immigration work done whatsoever, and I feel more relaxed, I feel more productive, and I feel like I've had that time to be able to adequately prepare and also work on things that I would put off. So several projects that we've got going on in the background, and just general things that you wouldn't be able to do during the week. So far it's been going great, and I am hoping that this 4-day week momentum will continue. Now, on one of our subsequent episodes, we do have a guest who's going to be discussing the ins and outs of the 4-day week, and we will be covering this topic at length. The other reason why this has become quite important to me is because when I was doing my research, the way that we work hasn't really shifted for about 80 years. So the last massive change happened in 1940 when a 38-hour week was introduced. But after that, there's been no major changes to the way that we work. So I do think that it is possible to do a 4-day week, but it does require great level of communication and requires great level of attention to detail as to how you spend your time. But surprisingly, it is not difficult to manage. But as I said, early days, let's do a check-in in a couple of weeks' time to see how things are going. And that's all that we've got time for this week's episode of Crystalcast. First and foremost, thank you everyone who do support us on a weekly basis. If you like this channel, please make sure that you click like and subscribe so that you can get instant notifications as soon as we put out a new episode. We've only got a couple of more episodes left for this season. I know there's still a few exciting things left to be announced before the year wraps up. And we've also got a number of guests that are going to be discussing a range of issues and also some quite interesting topics. So make sure that you tune in at the same place and same time next week. Until then, have a good day, and I look forward to seeing you at our next episode of Crystalcast. You take care.